In Canada, two federal laws sit at the heart of how the government handles information: the Access to Information Act and the Privacy Act. They sound similar. They're not. One lets you see what the government is doing. The other protects what the government knows about you. The Access to Information Act gives Canadian citizens, permanent residents, and anyone present in Canada the right to request government records: emails, memos, contracts, spending reports, the paper trail of government decision-making. It costs $5 to file a request, and the Information Commissioner of Canada oversees the process. The Privacy Act is different. It governs how federal institutions collect, store, and share your personal information. Tax records, immigration files, health data held by federal agencies, that's your data, and this law protects it. Filing a request is free, and the Privacy Commissioner keeps watch. Under the Access to Information Act, you can obtain briefing notes, research studies, internal correspondence, and detailed spending records. But limits exist. Information may be withheld if it involves national security, international affairs, or trade secrets belonging to a third party. These exemptions are meant to be specific and narrow, not a blanket excuse for secrecy. At its core, this act ensures politicians and bureaucrats remain accountable to citizens by keeping the paper trail visible. The Privacy Act is about what the federal government knows about you. You have the right to see any personal information the government holds, and to request corrections if something is wrong. The Act sets strict rules on sharing. The Canada Revenue Agency cannot hand your tax records to another department without a specific legal basis or your consent. One important note: the Privacy Act covers federal institutions only. For the private sector, a separate law called PIPEDA generally applies. The two acts work in tandem. When someone files an Access to Information request for a government report, the institution must redact any personal information about third parties before releasing it, citing the Privacy Act. Both acts share a standard 30-day response window, though extensions are permitted for large volumes or when other departments need to be consulted. So, which one should you use? If your question is, why did the government make this decision? Or how much was spent on this project? That's the Access to Information Act. If your question is, what does the government have on my file? Your CPP records, your border services history, that's the Privacy Act. Two laws, two purposes, both built to keep government accountable to the people it serves.